informative today as we go through the discussions. I'll let each one just briefly introduce ourselves like you've just done. My name is Brent Daub. I'm the senior founding partner for Gilson Daub. We're a multi-state workers' compensation defense firm. We do some other practice areas like longshore and subrogation recovery, and we do some general liability defense. But primarily, our focus is on workers' compensation defense, and we're currently in 9 states, from here in Florida all the way out to Hawaii.
Hello, I'm Christine Nixon-Calamari. Mr. Daub is my boss. I work for Gilson Daub. I'm an attorney, been practicing workers' compensation for over 20 years in Florida. And anything you need, I am available. Question, anything.
Super.
Absolutely.
My name is Jessica Whitmire. I am a multi-jurisdictional claims supervisor. I started in workers' comp about 15 years ago and just worked my way up. I'm one of the few in our offices who does multi-jurisdictional. I'm licensed in about 15 or 16 different states. I've handled all of it, multi-jurisdiction, municipalities, school boards, hotels, restaurants, gas stations, some longshore, all the in between. But we primarily do workers' comp, and that's what I look at.
My name is Anastasia Settle, and I'm a registered nurse and a certified case manager. I started out doing a regular nursing position, and then I entered a job in the newspaper, which might say how old I am. It said an insurance company needed nurses Monday through Friday, no weekends, no holidays, no mandatory overtime. I was like, for a mom, this is a great job. I didn't actually think it was a real job, so I kept my hospital job for the first 2 years. Not making that up. So I started working in workers' compensation quite some time ago, and I'm now the medical liaison at Carlisle Medical. We do case management, we do durable medical equipment, and we do pharmaceuticals. So I work with everyone to make sure that goes smoothly, and I do handle some cases myself. I do case coverage for my nurses, so I can keep kind of my boots in the mud, as it were, and we do everything from the Midwest on down and east. We have coverage west of there, but it's a little more spotty, so.
Super. Excellent. Well, we're gonna kick off. As many of you are aware, this Sunday we had a pretty big game on that most of the country tuned into. And one of the things that people enjoy about the Super Bowl is watching commercials. And I have a friend who is in the advertising business, and so he sells commercial spots and marketing spots and things like that. And in our recent conversation, he was telling me that one of the groups who are now occupying the largest purchasing of time on television are injury attorneys. And so historically, those slots have been occupied by car dealerships and restaurants and things like that, but your injury attorneys are now taking over some large purchasing for marketing and advertising. You see them on billboards, you see them on buses and radios, and I think a lot of the sports teams now even have official accident attorney of your favorite local sports team. And so what's happening is there's a lot of money coming into the industry of litigation, focusing on car accidents, of course, but a lot of work injuries. And so anytime that the economy takes a little bit of a dip or layoffs happen, we do see a rise in claims. You combine that with the marketing dollars that are now targeting people with injuries, the costs of handling claims goes up. And so one of the things that we wanted to do today is talk a little bit about how to manage some of those costs, keep them low by getting good outcomes. Certainly there's claims that are fraudulent, we litigate those, but a lot of the injuries get prolonged perhaps unnecessarily, and there's some issues in the process that we can try to help improve upon to get the people through the system a little bit quicker, to get better outcomes, as far as their recovery, to get people back to work, helping them feel that that the care that they're receiving is quality, and also trying to keep the litigation down. So we have a couple of topics today that we're gonna get some input on from our panelists. And one of the first things that we want to discuss is that initial claims reporting period. That statistics do show that when employers are reporting their claims timely, and when they notify the insurance company, they get all the players involved, it does have an impact both on the overall outcome and length of the claim, as well as the frequency of litigation, because when people feel that they're getting heard, when they understand what's going on, when they're getting their benefits, they don't tend to seek out litigation as often. So our first question comes to, when a claim is reported and getting the injured worker to a facility, how critical is that first step, and what are some of the tips or suggestions that our panelists could offer in setting that process up?
So one of the things that I encourage all of my clients that I have is to set an established set of urgent cares that you have. So be proactive. How many are, if you have multiple facilities or a main facility, who is the closest? Is it a Centra Care? Is it a MedFast? Is it, whatever, prime care? And have a discussion with them. Most of the time, the leadership at those urgent cares are willing to even do a discount. If you send all your people here for drug testing and or post-accident testing or for x-rays or whatever the case may be, they're willing to give a bulk discount. Depending on if you're self-insured or you have a TPA, having a conversation with your TPA as well, because they might already be having those conversations. Who do we have in network versus out of network? I have a big school board, and so one of the things that we discuss is, yes, we have a school board clinic, but what happens to those people who are outside of the, 8 to 5 or whatever, or 8 to 6? Do we send them, how do we save money in that area? So are there other urgent cares that we can partner with instead of just sending them directly to the hospital? So your first step would definitely be contract or have discussions with a couple different urgent cares in your area to see if you can work with them so that they know immediately this is who you go to, and it can be posted in a break room or in the office or wherever, people might pass by.
From a legal perspective, you have 30 days once an accident occurs to report it to the insurance company, but I would urge that happens immediately. Not only are you sending them to a clinic immediately, and if there's one established, it's easy. And if the managers know about it, which is key, that your managers are told that this is what happens and this is where they go once an injury occurs. Because a lot of times managers don't know what to do or where to send people once an accident occurs. So I would, in addition to getting the relationship with clinics, I would encourage that we set up or have conversations, training with managers to say, this is what happens, you need to report it. A lot of times they don't want to report it. They ask, how are you doing? And then just rest or send them home. I get that a lot. And that aggravates the claimants, and that's where they will entertain attorneys more once they feel like they're not being heard or they're not being sent to a doctor's office. So while it's 30 days legally, we want to make sure that happens, that managers know, fill out the report, contact the insurance carrier, get them to a doctor initially, and have that work status established immediately.
Can I ask a question? Are you guys self-insured or are you with TPAs?
We are self-insured.
Self-insured?
Okay.
No, we're insured.
Okay. So,
Expensively.
So one of the things that, as a TPA, what we have is we have something called report onlys. So even if they don't really want to make a report, if you still have them fill out the incident form, you can just kind of file it away and be like, this is a report only versus a true medical only where they're gonna go to the doctors. Because then, if that claim, 60 days down the road, he says, well, I'm still having pain, you open it, right, and you start paying on it, you already have the documentation that they really this did occur on 1/1, they did report it on 1/1, this was the manager at the time, that kind of stuff. age-old question of, well, why did you wait to report the claim?
Right, and I guess I have a question on that
Yep.
one, for ones that, when it's a first aid only, it still should be a report
Correct.
only as
Yep.
well versus not, so just to get in the habit of everything,
Yeah.
report only and stick it there, because then it could just be a $0 claim
Correct.
if it's just smooth and easy.
Yep.
But
So you're talking about cases where it's an individual who's
Yes,
injured, yeah?
Yes, sir.
What advice do you give to companies who are class actionable over, like respiratory is a long-term potentially? What risk and what establishment of principles do you have for companies employed in the who need to use respirators?
So, I don't have a lot of expertise in that area. I do have a hospital that we did have a lot of COVID claims, we did have a lot of respiratory claims. And there is no law right now with those claims. Everybody's just kinda like, well, what are you doing? Well, what are you doing? Okay?
Well, yeah, the reason I raise it is, I won't name the hospital, but there's one hospital group in Washington that recognized that some of their medical staff got COVID during their work and employment.
Yep.
But all the reports coming out is that they all got it socially.
Right.
They're not actually even admitting that they didn't give adequate protection to those people
Yeah.
in the hospitals.
So, you kind of have to step back a little bit further and have the discussion with the hospital saying, hey, what is your process? So like my hospital had a very specific process that they had in place of their own testing. So typically we would get the claims 6 or 8 months later. And so for Florida, if you report a claim that late, there is a monetary fine with the state of Florida. But they ate it because they knew, okay, these were my processes, these are my steps, these are the testing that we went through, and we are only reporting the claims that we're accepting. So each state you're gonna have to look at and say, okay, what is the reporting requirement? And do you really want to make case law? Is really kind of where we're at. Do you want to fight this and say, no, we're not picking it up? Or do you accept it because it's the right thing to do, but you're higher, you know, as a nurse, you had a higher chance of contracting it at work.
Right.
Especially if you were in that specific unit and you work so many shifts and things like that. So I always, when I speak to my clients, I'm like, listen, yes, what's the right thing to do, but you know, there's also a monetary value that we need to talk about it. Okay, is the claim reported 3 years late? You know, it's kind of at this point, because I would caution them, because there is no real case law out there. I don't have Maryland. I can discuss it with one of my other managers, but there's not a lot of case law out there right now, and it's really one of those, well, do you want to make bad case law?
Right.
And that's something I would caution them against.
Yeah, and that also goes back to the importance of early reporting,
Right.
making sure the team is coordinating, you know, with the employer representative, with the
Yep.
claims people, with the defense attorney, to make sure everybody's on the same page. We have the information, we have an objective. Oftentimes injuries is a one-time instance, but when you're dealing with something where multiple people are injured, you wanna have a good approach, so you're not working different strategies. Oftentimes in those instances, they may all be represented by, you know, the same attorney.
Yes, yes.
And so there is an approach that you wanna have, you know, maybe you assign all these out to the same defense
Yep.
attorney, and you say, okay, here's our strategy on all of these, and you know, that comes with communication, which kind of brings up another good point. We talked about the importance of designating a medical facility for them to go to, but with that communication piece being so important, where does the role of having a nurse case manager come into play?
Well, and again, if you have a good facility that you're sending somebody out to initially, that's usually a good working process. If you have, I don't know, that spidey sense that something might go wrong, I would recommend maybe getting a nurse involved to triage the claim before they move beyond that clinic, because we know, statistically speaking, the sooner a nurse is involved on a long-term claim, the less likely they are to become litigated and the less it will cost you in the end. So if it's somebody difficult, they could be just a difficult person. They could have multiple comorbidities. They could have family members that are on disability, and who doesn't want to spend all their time together, you know? So, I mean, there are a variety of things, so getting a nurse involved at that point. But when somebody is referred outside of that clinic, my recommendation is 100% find a nurse that you trust and ask them which doctor to go to, because we have a lot of great groups here in Florida, but at every group I can name at least 2 doctors that I would be like, no, don't go there. And just personally, I have a network of about 80 nurses in Florida, and we just text each other. You know, in Fort Lauderdale, where you were just yesterday, I have 3 nurses that are really great in that area, and I just text and say, I have a bad knee that we need to get to a good doctor. So who do you recommend? And then I'm gonna take that and give that to you, because we want to make sure, as nurses, we do want them to go to a good doctor, but we also want them to go to a doctor that is reasonable and is not like, oh, it's workers' comp, that means it must be Christmas, you know, because that happens. So, but we do like to become involved at that point, if only just to triage the file and follow it. We have a program where I work that I developed where we do triage and then follow it and only send out a field case manager when needed. But that nurse then is in contact with the doctor's office and with the injured worker, because sometimes they don't want to share everything with their employer. I one time had a guy who was literally a functional alcoholic, and his hand got caught in a mattress rolling machine, and it was, well, you just ate. We don't want to talk about it. But he shared that with me, and I was able to get him help through his EAP without affecting his workers' compensation and without throwing red lights everywhere. And he went back to work really a lot quicker than I expected, but I think it's just because I developed a rapport with him early on and he trusted me.
So each state has, so in Florida we get to choose, right? We get to pick where they're gonna go, and each state is very different. Like Georgia, you have a panel, but if you pair that panel, you get to still pick the doctors. You know, which is other states like Wisconsin, they can go to whoever they want. So, you know, having that communication, the first line of defense, is really gonna be your, almost a saving grace, and having people who know the doctors who are in the field, you know, having the conversations with them, cause it, again, I had a personal experience last week, where my dad's in the hospital and the doctor bedside manner was subpar, right? You know, and it kind of turns you off. And so when you have somebody, and especially the new upcoming adjusters who may not know all the medical terms, having a nurse to be able to explain, well, your MRI really said this, right? And this is what we're gonna do next, and this is why we're gonna do it next. You know, it's just another cog in the wheel so that everybody can work together, holding hands, to make the plan move forward.
Yeah.
Nurses make a huge, I'm sorry. I was just gonna say, nurses make a huge difference in the overall cost of cases. If you have the difference between a good doctor, we call it a good doctor versus a bad doctor, could be quite a bit. The exposure and the value of a claim that it could be resolved for can be tremendous. You can have one doctor who keeps someone out of work for the entire time, recommends unnecessary surgery, particularly for back pain, where it's questionable whether or not the person needs surgery, but could go with surgery. Some doctors, well, you can kind of have surgery, so why not? So it makes, with the nurse telling us, you know, stay away from this doctor and use this doctor is highly crucial, and it's cost effective.
And on that note, I guess I have a question, because our company, we develop a whole network of physical therapists or movement people, and you know, we're mostly first aid, but on the case where it needs to go into a claim or something, you know, our customers get the same frustrations of certain doctors that are just not. Do you also have networks of then physical therapists, or does it always have to be the physician?
No, we do have physical therapists
Okay.
that we prefer, like, I'll just tell you, like Northport, there is one. If you go anywhere else, I'm sorry.
Right.
You know, like you didn't call me first. I don't know
Yeah.
what you want me to say. You know, but different places, and the other thing is, it's not just the location. Sometimes you do get a really great location where it doesn't matter who, when, where you send there, they all do well. But then there are some places where I'm just like, no, they need to be on this person's schedule. And, you know, as you know, a lot of times they go in and they're seen by a physical therapist, but then for their follow-up appointments, they see a PTA. Those PTAs make a difference, so developing a relationship with them as well. And I just find that the adjusters don't have the time to call them on the phone, but, you know, I'm driving all over the place, so I can wait on hold while you go and pull that person. Yes,
Yes.
I'll be right here.
Yeah.
Because I wanna talk to them.
Yes.
And I've even done that before. I had one guy who's with this therapist, and I said, no, I need you to, he said he can't walk more than 100 feet. And I said, well, I need you to kind of distract him. He said, do you mean like during cervical distraction, which is where you kind of pull it? No, I need you to just distract him, take him around the whole facility, talk about different things, and see how far he goes. He goes, can I do that? No, you can't, because now we're just gonna talk to somebody else. And I just talked to the manager and I'll like somebody else. Like, when you train him, we'll try again, you know?
Definitely, and I guess my next, like, I wanna save the world from injury, pain, and like, you guys have a network, we have a network. Can't we all get together and like share our networks of like really good people somewhere? Or is that not?
No, that's what I do. Like, we have a texting chain, and I kind of developed it with about 3 other independent case managers in the state of Florida. And so we have one. I did not name the group. I just want to be clear about that. They call themselves, and I guess I am one, the Badass Case Managers. So we have Central Florida Badass Case Managers. We have the Miami Hot Badass Case Managers. We have, you know, the Southwest. Then we have a small group that's, I would say, Northern Florida. And so they're all big texting groups. The max you can have on a texting group is 32, and they're all maxed out. We have people waiting.
Okay.
You know, and there's only 3 of us that are on all of the groups so that we can coordinate, because sometimes you do have somebody that's looking for a specialist and you have to look outside of your area, because Florida is so litigious, and doctors that are not familiar with workers' comp do not want to see your patient. So out of state or outside the norm, so outside of orthopedics, dermatologists, very hard to find, GI, very, very hard to find. Sometimes a specialist like a plastic surgeon, very difficult. And these are things that we need sometimes, even cardiologists. I have had people that have needed cardiologists for their work comp claim, and it is difficult to find them. So you need to have somebody you can reach out to in those cases, because again, one doctor can really, really mess up
Yeah,
your claim.
absolutely. Our defense attorneys, we also have our lists of
Yes,
doctors. So,
yes.
so we will tell the adjuster, okay, we like this doctor or whomever. We conference with doctors quite a bit, not only to get to know them, but to kind of figure out what the prognosis is, to see if we can't get them in a certain direction and to get them off of, back to some type of work. I find that many doctors don't know that if the claimant complains a lot, they think that they have to accommodate, and that's not necessarily true. Doctors need to know that they can say it's time to get back to work. So we like to conference with the doctors to let them know what they can and can't do. Some of them are just fearful in
Yes.
doing that.
Yes.
Yeah, absolutely. One thing that I did want to point out also in discussing the whole reporting is, I think what we need to do with our managers is to let them know that if someone comes into work, and it may sound weird, but if someone comes to work with a sling or a brace, and they don't necessarily say it happened at work, someone needs to ask.
Yeah.
I get that almost every week. Someone needs to ask, did that happen at work? You can't rely on the claimant necessarily to come in and report it. And the judges are finding that if you see it and you're not asking, then you're kind of eating it. You need to ask the question. Why is, if they're saying, I'm in pain, well, why? Did it happen at work? And a lot of people don't wanna ask that question because you don't want them to say it happened at work, but you do need to get that question asked. Because later on, you know, when they do say it happened at work after getting an attorney, and you try to deny based on notice, that notice defense will not fly because you saw it. And you know, so judges are deferring to claimants in that respect.
How often do you all run into companies? I worked with 2 different companies, one who didn't really care too much whether it happened at work or it happened at home. They just want to take care of their employee.
Right.
You know, they had a really good culture about that. And then another company who was just like, oh, you know, like you cannot come to work until you see a physician, you know, don't do anything. It was totally different. And I see why they're trying to do that, but do you come across, I don't know, is that a trend of people who
So
don't care where it comes from?
it really depends on who you're servicing. So my school board has a lot of schools in it, and so we get a variety of claims, all the way, you know, custodials, bus drivers, teachers, all of it. And they are a bit more particular, but their situation is different because they have a clinic that the employees can go to, whether it's work comp or whether it's personal, it's free to them.
Okay.
Okay. Versus my hospital, where, you know, they're the most entertaining thing I have. I just get these random calls, so Jessica. And so we have to kind of talk through the logistics because there's a lot of gray in workers' comp. And so, you know, some of the things that might not technically qualify that would be picked up, you might pick up. Because, for example, I had a nursing home facility. And one of the things that, you know, we have to all work together. So work comp rate is a silo, and you guys are safety, so it's a silo, and liability is, you know, and so we all kind of have to have the continuing conversations of, okay, I've absolutely picked up claims under workers comp because if they had filed it under liability, we would have spent millions. So that is another conversation on my piece that I say, okay, well, maybe we would deny it under workers comp? Absolutely. But it would be a liability claim because they tripped over XYZ and they were on the premises and we own the property and whatever the extenuating circumstances, because the cost of benefit analysis.
Yeah.
Workers comp has caps, liability, pain and suffering. So it's kind of a give and take, you know, how much money do you want to spend variety. And so that's when you really need to have a good team, a good TPA, you know, good tools in your tool belt, case management, attorneys, things like that to really talk through, because it's never a flat answer. Everybody just wants a flat yes or no. Well, there's a little bit more to that,
Yeah.
you know, so.
It's always a yes, but, or a no, but.
Depends.
Yes.
Yes.
Well, one of the things that you brought up that I'd like to highlight is the discussion about returning to work.
Yep.
And so when we can return an injured worker back to a job, when they're active, when they're productive, the statistics show that the life of that claim does shorten. Not only are your costs, you know, with respect to indemnity benefits, temporary disability reduced, but there's other benefits. Before we look at an individual returning to work, there are some things that can be done prior to when an injury gets reported. And so perhaps we can talk a little bit about what can an employer do in anticipation of claims. How can they make the return to work process a little bit easier when and if, you know, that does happen?
Well, I've worked with companies before. I moved down to Florida. I'm not an original Floridian. I hope that's okay with everyone here. You said you're from like Jersey, right? Yeah, so we're on the same page. We're good here. You know, I worked a lot of manufacturing in the Midwest, and they would literally have either myself or the physical therapy company I work with, or both of us, come out and evaluate for what people could do based on normal, statistically normal restrictions. So it's normal to have a restriction of limited sit-stand, or no lifting, carrying, pushing, pulling over 5 pounds. And we started at 5 pounds just because that's usually the lowest. But going in and helping them find jobs, but also thinking outside of the box. So you don't have work where somebody can do that 8 hours a day. And that's wasteful. But do you have enough work for them to come in and do it 3 times a week for 2 hours? You can do that. And it keeps that person engaged. They still have to get up, they're coming in, they're interacting with their coworkers, and you have the same effect with the length and cost of that claim being decreased. There's also the option of reemployability, which is a company that helps put people who are on restriction in a charitable organization. So you pay for their time that they're working, but they're literally working for a charitable organization. And you get that as a tax write-off. But the other thing you get is endorphins. There's no monetary value on this, but it does reduce pain. And I used to do a lot of reemployability referrals, and I'm telling you, most of those people would look for a volunteer position after they return to work, either with the same or a very similar organization. So you are literally helping your community, and it's okay for an employer to find 1 or 2 local charities and work, with them. Just have reemployability, write the contract. That costs you less, and they know you're going there. So you develop a community rapport. You can make it up. Everyone in this room has been making it up. I told people when I got here, I've been making it up for more than half a century, and I'm still alive and well, and I drove here, and I'm alive and well. So, find ways to make that return to work, and if you can't, ask somebody else, because Jessica and I have a lot of ideas. About 50% of them are hers, and about 50% are good.
I have a quick question. You are with an employer, and I know you're new. Do you have a formal return to work?
We do.
program?
We have they have a pretty stringent protocol and processes in place, to the point where I work for Lennox HVAC company, and there's 260 branch offices throughout the U.S. So a lot of these technicians, they go out on assignment to do a repair or retrofit, etc.
Yes.
We have an app. So if an incident takes place on a particular job site, they have to go into the app and file that claim. If they don't, say for example, they have what they call a SKID ID, it's a service ID number. They go to service a particular unit, it tells them when they arrived, when they left, and at the end, were there any injuries or and if they answer, that was my next question, I'm glad you kind of segued in. So if we have an individual that at the end of the day says he wasn't hurt on the job that day, and now you file that away, and then a week later he comes back and he says, hey Phil, by the way, I kind of was stepping off the ladder on the back of the advanced auto and I kind of tweaked my back. What kind of cases that individual have? When you have a document
I think it
that he
helps.
didn't
It helps
record
to have that, and if we take a deposition or we're in a courtroom, we say, did you sign this? And it says, I didn't have an injury, that helps. But it's not a bulletproof vest,
No.
because you find someone
Right.
says,
No.
I didn't realize I was injured, or
Right.
my employer has an incentive that I get a pizza party ticket if I don't have an injury.
Right.
So I didn't want to, report the injury, I wanted the pizza party on Friday.
Yeah. But it is extremely important that
Yeah.
you have that set up
It's
though,
helpful.
because if the way to win workers' compensation cases on the defense side is the credibility of the claimant. If you can attack that, no matter how good their case seemingly is, I've won cases where I have no business winning because you attack the credibility. So if you have something in writing where this person says, I was fine, and then a week later, at least I have a prior inconsistent statement that I can hammer that person with in front of a judge, and it looks bad for them. So while it's not a slam dunk, it goes a long way in denying the claim and then settling it later for less. It's not only about just winning overall.
Right.
It's about setting the claim up in such a way that once it's time to negotiate a settlement, then I can have, when, you know, your guy lied, he said he didn't have an accident a week ago and now he's saying, I have it in writing, so we're offering you 10 and that's it. That makes a huge difference in 10 versus 25. So it's not just about the end result, but what happens in the process. Because
Right.
workers' comp cases are settled largely, and most attorneys would like to have it settled at some point because that's how they get paid. Most of, you know, a primary way for them to get paid. So that's a great tool.
So
It's an
really-
absolutely
so-
great
it's
tool.
helpful.
Yeah.
So in Florida, we have, the 120-day rule.
Mhm.
So you have, if you know how to TPA, you would put the claim in, and one of the questions when you report a claim is, do you question this claim, yes or no? So you would check yes, and then you could, speak with your adjuster or whoever and say, hey, listen, the reason I'm questioning this is because he reported it, he initially said no, now he's saying yes. We send out the letter, it is essentially saying, hey, listen, we have 120 days to investigate, to pay and investigate. Let's say in that time, we did a social media, and we found over the weekend, he was playing flag football on his Facebook, and we have a video of it, and it's forwarded to us in that 120 days, well, guess what, your claim's denied,
Right, that's good.
you know?
We have plenty of that, believe me. We have our system's pretty robust.
Yeah.
We have a relationship with Nurseline. I don't know if you're familiar with
Yeah, yes,
Nurseline.
yes.
I'm, like I said, I'm new to this, so I don't know, I gotta, like you said, open up that communication and dialogue with them to ensure that they don't just, hey, you know what, Nurseline, you just go to the ER and they see the ER doctor, and next thing you know, they're writing a script for them. So we try to, first and foremost, if an incident takes place, I'm the first one that they call.
Right.
And I don't have them call Nurseline until I get involved.
Right.
And so if we're able to give them OTC, right, over-the-counter medications, instead of getting 800 milligrams of Motrin, we're able to double up and just get something over the counter. We can manage that, but I think what really resonates here is you said managing the case and following up. If you have that follow-up, that individual feels that they're truly being, the
Right.
company cares about them.
Yeah.
If you, oh yeah, you had an injury, all right, go home and rest, and you call them a month later, hey Joe, how you doing?
Yeah.
It's like, wait a minute, you calling me down? Like, it could go sideways easily.
Yeah.
They could go to a doctor, and that's the other thing, the other caveat is, you can't control who that individual goes to. Listen, I wanna go to my doctor, I don't care about your doctor. And then, like I got one case, a guy fell like 10 feet off a ladder. Miraculously, he landed on both of his feet and then fell backwards, and he even had a backpack with a bunch of tools in it. Young guy, I don't know how he did it, but he literally slid like down the ladder, landed on his feet, and then came to rest on his buttocks. Didn't break anything. He reported it to the branch manager, they called me, we managed the case, he was back to work the next day. And then now all of a sudden, he's like, oh, I wanna go see someone else, I have pain in my legs, and we're able to get them, we have a lot of training modules, so we could have these individuals work a whole week and do training, and pay them the whole week.
Right.
And to
And
get
that's-
them, like you
and
said,
that's where
return
it
to work
boils
is so
down to.
crucial.
Who are your employees, right?
Right.
Are they a good employer, are they a bad employer? And sometimes you have to be strategic. Do we want them to stay home?
Right.
Yeah.
Or do we want them to come back and count paper clips?
And a couple of things on that, like, people that have, I work with a couple employers that they're like, we don't care what the restriction is, we can work with it. I admire that, I appreciate that, but if they have rotator cuff surgery, give them a couple days off, because I don't know if you've had rotator cuff surgery, I have.
It's terrible.
I'm like a really mean person when I have rotator cuff surgery. So like my husband said, it's never been repaired because I'm still mean, but I mean.
Keep swinging at us.
That's right. So
Re-aggravated.
that's one thing, count that cost as well, because
Right.
if you say, we do have a return to work process, but we also know that following a surgery, you may need a couple of days to rest. Be reasonable, even to unreasonable people, especially in those cases. The other thing is, if you have a return to work situation, please, please, please notify the injured worker in
Writing.
writing
Writing.
via
Yeah, and
certified
fill it
letter,
out.
and carbon copy your nurse case manager and your adjuster and your attorney on that letter, because as a nurse case manager, I'm gonna make sure the physician is aware. Maybe they don't have another appointment for 3 weeks, but I'm gonna bring that to the appointment and show the doctor that they were sent the letter, this is what they said, I reviewed it, and I thought it was appropriate. I just wanted to make sure he was aware. The doctors really do appreciate that, so being reasonable. And then one thing that we were saying earlier is that if somebody signs off and says they didn't have an injury, I have had meniscal tears and rotator cuff tears most often, but sometimes a pretty significant back sprain where the person really didn't know until like about 5 o'clock the next morning. And I would say that happens more often the younger they are, because the older you are, the quicker you feel it.
Yeah, he was a young guy, man, that fell off the ladder.
Sometimes your body like can handle that and absorb that for a while, but you know, after a while, that nerve keeps going ding, 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 and they're like, you know, now it's hurting me, it's bothering me, it's keeping me awake, and I'm like, I'm awake every night, you know, but, you know, just thinking those things out, and I don't know that that thought process occurs naturally, you know, I think.
That's a good point, because a lot of young people think, well, it asked about an injury, so I had an incident, you know,
Right.
but I didn't feel injured, so I put, no, there was no injury.
Yeah, I mean, it's not a certainty. I mean, obviously, you're gonna have to consider when we get that report from the Lennox Corporation that you signed up, you're gonna do, it's a case-by-case basis. You're gonna, assess whether or not that person, based on a totality of the circumstances, as to whether or not we should push that issue. I do wanna say, though, that in the return to work process, make sure that it's some semblance of a real job.
That's a good point.
Yeah, there is some kind of a real job that you really kind of need, and it fulfills the need, because there's something called sheltered employment. And if someone comes in and they're counting paper and it's not really a job, judges don't look at it as a job. So we wanna make sure that it's somewhat of a real job that's promoting the company's interest, and that way we can, you know, assert to the judge, Judge, it's a real job, it's $15 an hour, it's 5 days per week, it's 4 hours per day, and, you know, so we just wanna make sure that that happens.
And all those things would be in the modified.
No, the letter is,
the
yeah,
letter.
absolutely. I just had one employer just yesterday send a letter, because, you know, my adjuster called me up and said, listen, I'm gonna send, I'm gonna deny, give me the language to deny indemnity benefits, and I'm like, well, you know, I was like, why? She said, well, there's a job offer, and I was like, how was the job offer made? And, well, the adjuster's been, the employer has been talking back and forth with her, offering her a job. Why don't you come back to work, we'll get you working. And I said, well, that's not enough. You need to put it in writing. You wanna spell out certain things. You wanna spell out the days of the week, how many days per week, how many hours per day. It doesn't have to be a full day. You wanna spell out how much it's going to be paid, if it's the same rate as the pre-injury wage or a different rate. And for sure, you wanna make sure that person knows how and when to report to work. A lot of times you send out a letter and they don't know who to call or when to report, and they have to know, okay, call, you know, this number by this date and speak to so-and-so, and then they'll get you started. It needs to be with that kind of specificity in order to make a good defense. Because I wanna tell you, as an attorney, the defenses I hate the most are defending indemnity, TPD benefits, and major contributing cause, which is another issue. It's a fool's goal. We keep saying, oh, they offered light duty, yeah, let's deny. It doesn't work. You lose almost every time without that letter. I don't wanna go to trial without the letter. And when you terminate someone, that's something else. Oh, we terminated him for cause because he wasn't performing well. But there's no track record, nothing, and you terminate someone and then you say, well, we'll stop paying indemnity, and it's again, adjusters call and wanna deny it, and it's not a good denial, because the reason why you terminated that person isn't a good reason. The reason has to be, even if the person wasn't performing well, but it has to be significant enough where that person, it's called misconduct in the law. So it has to be to such extreme that, a judge will say, yeah, you know what, he's been violating policies and procedures, it's documented, there were warnings, and that way, it's a good fire. Not that you can't terminate someone for any reason, you can terminate them for whatever reason in Florida, because it's an at-will state, but if you terminate them, don't believe that the workers' compensation claim is resolved because they're terminated, because it's not. It can make it worse, but I always tell employers, and I speak to employers a lot, in every single one of my cases, I call them within the first week of getting a new file, because getting their input and tidbits from employers it's crucial for any file. So it's just really important to have the employers play an active role, and I tell them, fire them if you want, it's your right, but it may still, you won't get rid of the workers' compensation claim. Yeah.
So, going back to what we heard over here with late reporting, we're hiring about 100 people a month and across the country, but when we onboard them, we tell them, you know, here's the process. If it's a minor injury, you put a Band-Aid on. If it's anything more than that, we use a company called Work Care. Some of you may have heard of them. And we actually, we're swapping to another company called Job Site Care that they put you in touch with a doc, FaceTime, whenever you have an injury. And so we're pretty good about getting that word out. We tell them, it's like, when something happens, you need to tell us now. And and then I tell them, it's like, one of you in here will come up, you know, 3 weeks from now and tell me something happened last week, and I'm gonna tell you that I told you so. And it goes like that, right? But if we have a guy that you know, comes up and says, hey, you know, I'm calling in this morning, I hurt my back. When did you do it? 2 weeks ago. How did you do it? Well, are there any witnesses? No, you know, I'm just telling you that I did it. What's the implications of saying, well, you should call your personal physician and go get it checked out? I mean.
It depends on the state. I hate to give such like a.
Because we're to the point now, this has happened enough, right? And we tell them, and we tell them, it's like, hey, you know, if it's 3 weeks later, don't even bother to tell me, right? I don't wanna know about it, because 3 weeks have gone by, I think you're full of baloney, and take it to your personal dime.
So,
A lot of these people are in Nevada.
Oh, okay, good.
Nevada. But Nevada's a state where I understand once somebody gets injured, you own it forever, like it never closes, is what they're telling me.
I'm not
And
sure.
some of them are in Arizona.
So the one thing that you do have access to is it's called an ISO search. So if you are not vested in it, it's like $13 a report. But what it does is anytime that they have any type of accident, it could be a car accident, it could be a prior workers' comp, it could be liability, it could be medical. You pull their information. So you enter in, you know, name, date of birth, social, all the information you have in the database, and it will pull a report. And so as a TPA, the first thing that we do is if I see that, I will pull the ISO report to see if there's any other accidents that have occurred in that time frame, and or maybe he had an accident a year ago for the same body parts. Like he injured his back.
So he would have had to been in the medical system, and it would come up on this
Correct.
report?
Is that a free service?
No, you
No,
don't.
you
It's-
do have to.
you
You
do
I
do
thought
have to pay for it.
someone
I think
mentioned to
insurance
me,
carriers
when I worked up in New York, there was a website that you can check to see if individuals had like workers' comp
Oh, okay.
claims and cases.
So, state of Florida, there is a site, the OJCC website,
DOA.
the
What's it called?
DOA.
Oh,
So
Joe, it's called
yeah.
jcc.state.fl.us, that's the
Yeah.
website, jcc.state.fl.us.
Yep.
Do you use that a lot, Christine?
Yeah.
You
think? Every day.
I know.
Yeah.
Every day.
Yeah, to your question, every state has reporting requirements
Yep.
and statute of limitations, and some are stronger than others.
Yep.
Nevada does happen to have one of the better ones for that particular issue.
For an employer or for the employee?
For the employer, there's some strict reporting that is required. California has a statute of limitations that's rarely enforced, so we
Yeah.
often get claims years later. And they have cumulative trauma claims, so you
Yeah.
don't even have to point at a specific injury, it just happens over time. So yeah, definitely be aware of the jurisdictional
Yeah.
requirements
Yeah.
on that. Well, we're getting close to the 1 o'clock cutoff time. I did want to open it up if there's any other questions, because obviously your questions are very valuable to us on
I
providing
have
good
one,
feedback.
cause I had a old friend in Colorado who they have a great employee, they said, who had a back injury or something, who's been seeing someone, and they really liked the clinic, it was already pre-set up, and all these things, they're like, they're just not getting better, and I was like, I know these other people who are really good at what they do, like that whole network thing, I'm like, can you switch them? And I don't know that, can they, if they're already under the care of a certain physician or physical therapist or clinic, it depends.
It
Just switch.
It depends on the state.
And who
So,
can make that choice, or
in
does it have to be?
Indiana,
employee?
the adjuster or the nurse case manager or the employer is the one who has the right, but the adjuster and the nurse case manager are acting on behalf of the employer. We can change the doctor as often as we want. Now, know that if it is litigated, you might get your hand slapped for doctor shopping, but again, count the cost. Is it worth it to doctor shop? But I've seen patients change 5 doctors because the adjuster didn't like the answer she was getting, even though I was like, no, Dr. A was right. Actually, Dr. B was right as well. Dr. C and D, they concurred with A and B, you know?
Okay.
So it depends on the state as to who has the right to do that and how that occurs. So again, in Florida.
In Florida,
What state?
yeah, in Florida, if someone, usually it's the attorney that requests a one-time change is what they call it. And usually you can't make a claimant, if they like that person, you can't make the claimant not go back to that person. You have to stick with that person. Unless you do something called a utilization review, which is not really done that often, where, or an IME, independent medical, independent medical evaluation, where the adjuster could say, well, you're not getting the proper outcome, and I'm gonna do an IME and use this to try to get you shifted. Or a utilization review is the other way.
Okay.
But it's not really, in Florida, it's very difficult unless the attorney wants it, or the claimant wants it, and request a one-time change.
Okay, cause I mean,
Is
the
it-
forever optimist in me had never realized
Yeah.
doctor shopping and all the things, you know, we're just like trying to get the person better.
It's not a 0-100 kind of answer, but I will say this. In Florida, most adjusters do not want to use their IME because they only have one. But in other states, some states you can do unlimited IMEs, and the other thing you can do is if you get an IME, you got injured, you're treating with him, but I send you with an IME to him, and then you go back to your treating doctor and he follows that. After so many weeks or months, I can send you back to the IME doctor to say, he did this with so-and-so, shouldn't he be better now? So it does depend vastly, but an IME might be a good idea. You can do a peer review, which is just a medical record review. We do that. I oversee the peer reviews and the utilization review. So when we get one in, again, not 0-100, if Jess sends me one, I read through it, but I may reach out to her and say, based on the questions, this looks like you're doing this. Can we change some of this way? And then when we get the review back, it comes back to me, because even though you're paying these peer review and utilization review doctors a huge sum, they like to be vague in their answers, and I'm like, no, the question was pretty clear cut. So I'm gonna need you to come down on either yes or no. Maybe's not an option. So you kind of have to do that and have somebody there who's interacting with the physician. Again, somebody who uses a nurse, because, I mean, think about it, Jessica has a huge ton of medical knowledge, but the doctor tends to respond better to a nurse because they feel like it's a professional respect.
Right.
So you just tend to get a better result.
How long has this person been treated?
I'm gonna say it was 4 months or something like that, or
Well,
longer.
that's not long.
That's not
Well-
long.
Yeah.
Not for Florida.
So I have a question. So based on your experience in cases, what's the percentage of claims that are coming in when individuals work for a short period of time? So like the new worker, I mean, I find it, and I think you could probably agree with me, that a lot of these cases that come in are individuals that are not that experienced yet in the field.
So,
And so,
I feel like it goes back to his original, when the economy is good, you have less claims, when the economy is bad, you're gonna have more claims. Because I mean, so then it really goes to your employment. When you hire them and they're filling out that application, do you have
The vetting process?
Do you have questions? Have you had a workers' comp claim? Yes or no? You know, what do you do to vet them after that? And that, we have, going back to my hospital, we have an employee who was actually truthful. I was completely surprised. This lady had a fusion, had a neck injury, has a laundry list of pre-existing, but she was honest on her employment application. Should they have hired her? Probably not, but they did. So, you know, most of the time, most people will not be honest on their employment application.
Which is a good defense for us. I would say this, I'm seeing it more in the construction industry,
Yeah.
restaurant industry, and landscaping, where new workers are like immediately within, that it's a revolving door. And so in those three areas, I'm seeing it quite a bit where the younger workers are getting, or newer workers are getting injured more. And a lot of times, you know, there's a lot of reasons for it, and probably we don't have time to get into all of the reasons now, but I'm seeing that. What she is speaking about though, with the application process is extremely important. If your application has like a medical questionnaire that asks about prior injuries, it gives us a great defense if they lie on it. And we can easily find out if they've lied on it by getting the ISO report, or just sometimes in a deposition, you start asking, you know, about past medical history or a medical canvas. You know, those are things that we'll utilize to find out. And if we find that they lied on the questionnaire, immediately we have what's called a Martin v. Carpenter defense, and we can shut it down. So yeah.
One of the things that my big school board does, they have them sign, so after they sign the notice of injury, we have a form called a medical authorization release, where they're required to list their doctors and sign at the bottom. HIPAA does not apply to workers' comp, so I can, if I do a medical sweep and I see that you've been to 10 doctors, well, that medical authorization form is going over there and I'm requesting all your records.
Yeah.
And please do that, because medical records in the state of Florida, it's not true for every state, again, it varies. In Florida, it is very difficult to get medical records. I can't tell you the number of times I've been assigned to a file simply to get medical records because the adjuster has done everything they can and they are now bald. It's just not a good look, but pulling your hair out from medical records will definitely happen. It's a real diagnosis here in the state.
Well,
And this, I know, it's been super helpful,
right.
I'm just gonna sneak in one more, and just in regards to the whole, do you have, something to fill out that says, do you have previous injuries? That's also where a pre-hire physical testing
Yes,
helps
yes,
you
yes,
as well.
absolutely.
I just
Yes,
know a lot of
yes.
companies don't wanna spend that money right now, and they just need bodies.
But really, yes, everybody needs bodies, every industry is
Yeah,
struggling, right? But that's where the numbers come in. Pull the report, how many injuries have you had? How much money are you spending, right? How much would it cost if we had somebody come in, do a trial run, do 3 months, okay? And then compare those two costs. Now, are we saving money because we've hired this company for 3 months versus all of these claims that cost X amount of dollars?
And there's no one in here that I know of that is represented in this area, but for goodness sake, find somebody that does social media polls, and the minute you hear that they have a claim, do that social media review, because the next minute when they get their attorney, they're gonna be pulling all of their social media profiles. Do that right away. And find out who their friends and family are, because we've gotten people before, because they shut down their media profile, but we knew who their friends
My
and
mom
family
still
were.
has them tagged.
Yeah, still caught them.
They'll say, had an injury this weekend at the lake or something.
Yeah.
You know, it's surprising. Well,
Cool.
we do wanna honor everybody's time. We'll certainly stick around for any
Yeah.
additional
Great.
questions.
This is great.
Thank you.
We really
Thank you
enjoyed it.
so much.